Please be seated. The next case set for oral argument is J-2 Investments, Inc. versus Leon County. Before we start, I'd like to welcome Judge Hankinson, who is sitting with us today. He volunteered his time because normally we'd have had Judge Allen sitting on this panel, but he retired effective the end of last month. So thank you, Judge Hankinson. I look forward to sitting with you. If the parties are ready, appellant.
Good morning, Your Honor. My name is Tom Gilday. I represent the appellants Johnny Petrandis and JP2 Investments. I will tell you it's a little odd to be here this morning talking about an order rendered by Judge Davey after having sat at his memorial service on Saturday. A good, fair-minded judge that we'll all miss in this circuit. That said, maybe I can address where he went awry on this particular case. That we're here on an order of contempt, and to understand what happened, where we got, I think there's a minimal analysis that you need to do.
Well, technically, counsel, we're not here on the contempt order, are we? We're here on a later order that really dealt with the issue of your client's purge or attempted purge of the contempt order. So the contempt order is not on appeal.
Well, actually, I think it is, because what we were procedurally, and that's why I started getting into this, procedurally, we were there on a motion for rehearing of the contempt order. Judge Davey had imposed the millions of dollars in fines based upon Judge Ferris's order holding Mr. Petrandis in contempt and granting a purge. Mr. Petrandis could purge that if he filed a completed application. And so what happened is they went to the hearing on that. A motion for rehearing was filed because the Parisi elements were not filed during the initial hearing. Judge Davey recognized they needed to be filed, and so he granted a rehearing, and we went forward on that. He then took evidence, and then he entered his order, the October 2008 order, in which, frankly, we think he went astray at that point in time. And let me indicate to you where he went astray. First, when you look at the order, what he held was that he fined Mr. Petrandis roughly $250,000 plus some costs for not remediating the property during the period of time.
I know in your brief you've consistently used the term fine, and I understand why you would do that. It strikes me reading the order and the record is it's really more the cost of remediation is what he appears to be imposing. And because to reach that amount, he did a calculation coming up with his own conclusion of what a fair cost of remediation would be. So it's not a fine in the sense that he just grabbed a number out of the air and levied a fine.
Well, Judge, and I think the Parisi case and the other cases that come after Parisi make it pretty clear that if you don't have the ability to purge the contempt finding, then it is a criminal fine, a criminal sanction, and all the due process requirements of that particular statute and rule apply. And I think that's where he went astray, because when you look at his October 2008 order, there's no opportunity for purge. Mr. Petrandis cannot purge that order. His obligation is to pay the county roughly $300,000, 300 some odd $1,000. He has no ability to purge, to do anything to purge that order.
Let's go to the order. The order, paragraph 4 says, in order that defendant's contempt of court be purged and its unlawful destruction of the property be remedied, he shall pay this cost. And I'm paraphrasing a little bit, but I mean, Judge Davey specifically says that's how it's purged. So I'm a little confused by how you say there's no purge option.
Well, what he's obligated to do is pay a fine to the county. That doesn't remediate the property. There's been no permit issued by the county that would allow Mr. Petrandis to go forward and remediate the property.
And Judge Davey found that the reason there's no permit is that your client has not been acting in good faith to pursue that permit.
Well, and I think that's important we address that issue, because what happened here, I think, is Judge Ferris, back in 2006, really understood what the issues were, and she entered her order, and I think it bears looking at, because when you look at it, I think you understand where this thing went astray. Paragraph 2 of her order, what she says is that she found Mr. Petrandis in contempt because he had not filed an application, a completed application for a permit. You have to get a permit before you can do any remediation. Paragraph 2, she says, the defendant shall purge themselves of contempt by submitting a complete application for a standard form environmental permit on or before May 23, 2006. Everybody seems to ignore the last sentence of that paragraph, in which she says that the plaintiff shall accept the application of the defendants for the standard form environmental management permit while the natural features inventory submitted by the defendants is still pending. And the reason she made that distinction, when you go back and look at the transcript, is that she understood that a permit is, and it's attached as in the appendix, B and C to our appendix, it's a checklist that you go down and check what you're supposed to do, and that the natural features inventory deals with issues that the county has to deal with, such as how much property does the property owner have to dedicate for a conservation easement, what type of karst investigation they have to do, what type of floodplain, all that type of thing. That's what the natural features inventory was. And what Judge Ferris understood was that that was going to likely be a contentious issue. And she wanted to make it clear that Mr. Petrandis wasn't going to be held in contempt for arguing with the county.
Counsel, I think Judge Van Ortwerk's question went to the county's first argument in their brief, which is all of that discussion is barred by res judicata. That you didn't challenge that order, and that you can't, and I'm not saying you can or you can't, in my view. I'm just suggesting that if you could step back and explain to us why you get into the merits of Judge Ferris's order, I think that would be helpful.
Well, I'm not getting into the merits. We're not challenging Judge Ferris's finding of contempt.
You're saying you met the conditions of her
what
order
we're saying
by
is
filing the application.
2 weeks later, Mr. Petrandis filed
We all know that there's an application.
the application. And so he complied with the contempt. What happened was, when it came in front of Judge Davey the first time, and this is kind of where I think the county is culpable in this matter getting off track, is the county represented to Judge Davey that Mr. Petrandis had not filed a completed application, and they were adamant in taking that position.
Let me ask a question about that. First of all, did you give us some time?
I didn't, but I need to save 5 minutes.
All right. Well, you're
and I'm getting close.
2 minutes and 20 seconds before you hit the 5 minutes.
Yeah, I realize that.
Let me ask this question. I know like a week after the application was filed, the county
2 weeks.
responded with a relatively short period of time with a checklist of items that weren't covered. Some of those clearly are part of this NFI process. Others appear not to be, because they relate to things like subdivision of the land. If part of that checklist relates to inadequacies of the permit application, wasn't that something that you were obligated by Judge Ferris's order to notify the court about?
I think so, but I will tell you Mr. Petrandis' view is that he complied with all of he thought he had complied with the complete application.
The question, and I had the exact same question on my mind, is that order required, let's assume you're absolutely right, he filed the application in good faith, but Judge Ferris said, I know this is going to be a contentious permitting procedure. That was obvious to everybody. Now, everybody knew what you filed on May 23rd. The county was likely not to turn around and say, great, totally complete, everything's good. They were going to come back, which is typical in the development process, and say, we need ABC. You were obligated to notify Judge Ferris, it appears the county contends our application is not complete. We think it is, and this is why, but we're going to continue to work with that county. That notice was never filed with Judge Ferris, correct?
I agree. We didn't send it in, and the reason is because Mr. Petrandis thought he had filed a complete application, and all the dialogue was about the size of the conservation easement and what the remediation plan was going to be. When it reached Judge Davey in 2007, that's essentially what the issues were. The county didn't represent to Judge Davey that we got a hang-up over the size of the conservation easement or the remediation plan. Well, it says not complete. And Judge Davey said, well, you haven't complied with what Judge Ferris required. And therefore, at that point, he imposed the fines. And obviously, it's a question on your appeal. You're not going to appeal a contempt order that you think you understand. You're going to appeal it when it becomes clear that the county has one interpretation, you have another, and fines have been imposed against you. Because had the county, had the same interpretation we did, we never would have been in this.
You're really appealing Judge Davey's finding that there has been no purge of Judge Ferris.
That's correct. And that is really when you read his October order, that is still part of his order. He doesn't. Now, I will point out to you that when we finally put the application in front of Judge Davey in November of 2007 and went through each aspect of it, and then when the county had an opportunity to place their evidence at the continuation in January of 2008, Judge Davey lifted the contempt findings. He found that we had purged contempt. So I think that's how we got into it, and I think that's what it led. I think I've used my time based upon the...
You have approximately 4 minutes.
Right. I'll save that for rebuttal.
May it please the Court. Good morning. My name's Herb Tila. I'm the county attorney for Leon County, the appellee in this particular case. Let me just start with what Judge Van Noordbrink said at the very, very beginning of appellant's argument. This is a continuum. This whole case cannot be looked at in isolation. You need to look at each of the 5 relevant orders before you can look at the final order that was issued in this case. And here's why I say that. The original order by Judge Smith was a finding that there was a violation by these individuals. That was appealed to this court and upheld. Thereafter, the appellants did absolutely nothing to fix any of the significant environmental damage that they had done to this piece of property. And so we filed a motion, and Judge Ferris heard it, and Judge Ferris specifically found that he had done nothing such that his conduct was sufficient to be contemptuous of the court. Judge Ferris then imposed a per diem fine, which the Parisi case that the appellants have cited to this court specifically endorse as a proper civil contempt methodology to coerce someone to comply. That coercion fell on deaf ears. And a significant period of time again went by when this appellant did not submit the completed application that even if you look at Judge Smith's order, that order indicated that a completed application was a condition.
Let me ask you a question on the per diem fine. I'm a little confused. Let's say he went a couple months where this fine is supposedly accruing, and we ended up $2.3 million was the calculations Judge Davey found. At the point he complied with everything, would that fine have gone away in your estimation, or is that just the fine that would be due and owing up to that point that he finally complied?
Yes, sir. In my opinion, the fine up to that point, the $2.3 million, was a fine imposed by the court, not by the county. Right. And at that point, the fine would stop running, but it would have accumulated to that point.
So what Judge Davey really did is mitigate the fine.
Yes, sir. Right. I think that he took to heart the matters that are raised in Parisi and other cases that seem to indicate that in a civil contempt context that you also need to take into consideration, and I don't agree that that may be applicable here, but the court believed that in order to assess this fine, the court needed to take into consideration the damage done and the ability of the appellants to pay. So that's why Judge Davey granted the rehearing only on that issue. Should the $2.3 million be imposed, or should another number be imposed after taking those other factors into consideration? And what the court found, and I think that's an interesting aspect of this order which shouldn't be overlooked, the court never imposed a fine after the rehearing. The court imposed on Mr. Petrandis a requirement that he pay to the county some $300,000. What's that for? $60-some-odd thousand is a reimbursement, if you would, and so to a certain extent you could call that the fine for the amount of money that the county had to expend trying to get compliance, which, by the way, still to this very moment has never occurred through all of these orders by the court.
But the appellant's argument is we submitted an application for a permit. Despite repeated attempts, it's never deemed complete by the governing authority. We're told don't do any action without a completed permit. We plant 25,000 trees. Then we're told you planted trees in violation of the order. I mean, they make what could be perceived as a compelling argument that they're placed in a catch-22.
Judge, I understand that, and the answer is they were always on notice that their application was significantly deficient, and they had a remedy if they disagreed with us. That remedy was to go back to the court all the way up through to the end of the hearing with Judge Davey and say, no, the county was just giving us the runaround. But you will see in the record there are at least 7 written communications from the county, because Judge Ferris required that list in excruciating detail all of the deficiencies. If they said that's not right, that you all are just trying to run up a fine, as they seem to indicate, no, then their remedy was to go to the court and say we've purged the contempt fine. So the issue that the appellants raise here, that Judge Davey's order doesn't contain a purge, mischaracterizes this string of 5 orders. The purge was contained in Judge Ferris's order. $1,000 a day fine, followed by $5,000 a day fine, and the purge was you needed to file a complete application. Then Judge Davey held a hearing early on, and I believe that's in September, in which the court found that they had failed to purge. They had failed to purge, and they had failed to avail themselves of this wonderful opportunity to go back to the court and say, wait a minute, that's wrong. We have a complete application. We'd like an evidentiary hearing to prove that. So that, in my opinion, Your Honors, is where we found the case when the last order by the trial court came to be. In other words, they failed to purge. They failed to go back to the court to say that the county was not allowing them to purge. And then Judge Davey entered an order finding that he had not, even in good faith, tried to purge the contempt. That's when the $2.3 million fine was imposed. And in the rehearing attempt, Judge Davey attempted to apply those other 2 factors, the financial capability and the amount of damage. He specifically found that there was evidence in the record by the county, by our expert, that the remediation costs were to be a certain amount. And as Judge Van Noordwijk correctly indicated, he then did his own calculation and took out certain amounts of money. He specifically found that the quantity of money that was for the gopher tortoise eradication was too speculative and took that number out. So he specifically found a number based upon expert testimony in the record of how much it would cost, how much the damage was, how much to remediate the property. That money is going to be used to remediate the property, and I think that's something that the appellants still don't quite understand. That's not free money to Leon County. That money is going to be used by Leon County to remediate the damages done, because the court specifically found that it had absolutely no confidence that Mr. Petrandis would ever do that.
Well, address the appellant's argument that because Judge Davey specified that the only option the defendants had was to pay this $314,000 amount, that it converted this into a criminal contempt because there's no purge option other than the payment of the money.
Okay, and I understand that. My position is that the purge option occurred in the contempt order, that all this order did was to set the amount of the fine following the contempt order. So there didn't need to be a purge in Judge Davey's order because all he was doing was setting the amount of the penalty, the civil penalty, to be involved. And in fact, as it turns out, the $2.3 million went away. So the purge was to file the complete application, which, by the way, they still haven't done. And then they were to petition the court if they didn't do it, or we said they didn't do it properly. So in answer to your question, Judge Davey's order did not have to have another purge provision. That purge is to pay the amount of money ordered. So it did not convert it to a criminal contempt. It is still remains civil because the conditions of an indirect civil contempt were met. There was evidentiary hearing, significant evidence in the file, opportunity to be heard by the appellant, a ruling by the court on the evidence, a fine, a coercive fine, as Parisi indicated you can do on a per diem basis with a purge. File a complete application and the fine stops running. So what Judge Davey did was to look at the quantity of the fine and apply those other two factors. And Your Honor, I believe that was not a conversion into a criminal contempt.
Now, under that October 2008 order by Judge Davey, I guess that one of the effects of that order is that the appellants no longer have an obligation to pursue the permit?
No, they still have to pursue the permit if they intend to do any of the action. At this point, it is at least my position that we're going to become the property owner for purposes of remediation. We will have to apply to ourselves, if you would, for a permit, and we will have to get the work done utilizing the $200,000 and some odd that the court has indicated is to be set aside for that purpose. And so we're the applicant now.
That's how I read the implication of the order, was that the county was going to take these funds and do the remediation, so the county would, for that purpose, be the landowner.
Yes, sir, and I think that's a correct reading. We have stepped into the shoes because the court said and found that he didn't believe that the appellants here could be counted upon to do that themselves. So with that, Your Honor, I believe that the court's order that's here on appeal, the October order, should be upheld and the appeal dismissed. Thank you.
Your Honors, as I read the Parisi decision and the other decisions which followed it, there is no way that Judge Davey's order can be anything other than a criminal sanction order. There is no purge. You know, if you think about procedurally what we were about on the motion for rehearing, Judge Davey correctly realized that the county had not placed evidence in front of the trial court in terms of what Mr. Petrandis' financial ability was. In fact, they objected to attempts to put that testimony in. But Judge Davey recognized that it had to be done. And so he granted a limited rehearing on that basis. And so the only thing that the testimony was presented was, what are Mr. Petrandis' financial capability, and does the fine that I'm going to set, that does it bear a reasonable relationship to the damage? That's what Parisi says. And so what he should have entered was an order which said that I'm going to find that a reasonable fine is maybe, while we would dispute whether the right calculation was done, $250,000, that Mr. Petrandis, if you don't and we're back to the complete application. If you don't file a complete application and you don't go forward with it, then you're going to be subject to this fine. That's what.
In your view, Parisi imposed an additional requirement on the trial court here to continue to give the appellant an opportunity to file the quote complete application.
To purge. There has to be, if there's no opportunity to purge, when you read the Parisi case, the other cases that follow it, there's no way to escape. That's what the law is. And if you don't have an ability to purge, it just becomes a fine, as it is in this case.
What do you say to your opposing counsel's argument that your opportunity to purge, so to speak, was when you were informed that your application was not complete, to go back to Judge Ferris and say, okay, we're in a dispute. We say it is. They apparently say it isn't. We think you need to find that our application is complete, and this is why. We hired a consultant. We filed what, on paper looks like a good faith effort, and they say it's not complete. We say it is. Judge, you need to decide.
Well, and that's a good question. And what actually happened is, at the point that it became apparent that the county was not going to accept this application as complete, Judge Davey had been assigned to the case, and I don't think that he appreciated what Judge Ferris's concerns were that she put in the order that I read to you right off the bat, which was she made a very clear distinction. And the reason this came up was before Judge Ferris became involved in May of 2006, Mr. Petrandis had already started the NFI process. He had submitted some information to the county. There was some dialogue going. It wasn't acceptable. So when it comes to Judge Ferris in May of 2006, she says, wait a minute, I know that can be a drawn-out procedure. What I don't want to happen is nothing to happen while you two are arguing over it. So I'm going to put it in order here, Mr. Petrandis. You start the process by filing the application, the standard form application. She was very concerned as to whether there was such a document and that whether Mr. Petrandis could do that. And he did that. And she was very careful to distinguish that the county had to accept the application while the national features inventory submitted by the defendants was pending. And what we have been arguing about since that before the 2006 hearing are the natural features inventory items. Mr. Petrandis was never held in contempt by Judge Ferris for not agreeing to give the county 20 acres of his land. And the county wanted 20. He wanted to give them a lesser amount. That's what the dispute was when it comes in front of Judge Davey in May of 2007. That was not what he was held in contempt about. He was held in contempt for not filing the application. That's what Judge Ferris was all about. Now,
your time's expired.
Thank you, Your Honor. Appreciate your